My name is Gary Strauss, and the case that I chose to discuss for the Week 2 case study assignment is Behrman versus the University of Notre Dame from Chapter 3 of the textbook, Case Studies in Sport Law. A quick summary of the case. Christina Behrman suffered a broken leg when she was knocked to the ground by a drunk as she was going to her car near the end of a Notre Dame football game. She and her husband sued the University of Notre Dame for damages resulting from the injuries. After all of the evidence was heard, the trial court granted Notre Dame's motion for judgment on the evidence. The Behrmans appealed the ruling. They raised one issue. Did Notre Dame have a duty to protect Mrs. Behrman from injury caused by the acts of a third party? The case was heard in the Indiana Court of Appeals, 3rd District in September of 1983. The facts of the case, on October 27, 1979, Mr. and Mrs. Behrman attended a football game at Notre Dame. They left the game just before it was completed and were walking to their car. They observed two men fighting, both of whom appeared to be drunk. One of the men fell down and then they walked away from each other. One of the men walked past the Behrmans. Moments later, the man fell into the back of Mrs. Behrman, knocking her to the ground. Mrs. Behrman suffered a broken leg in the fall. There were no ushers or security people in the area when the incident occurred. The Behrman's argument was that she was a business invitee of the University of Notre Dame, and because of this, Notre Dame owed her a duty to protect her from injury by the acts of other persons on the premises. Notre Dame's defense, they argued that because there was no notice or knowledge of a particular danger to Mrs. Behrman, the university cannot be held liable for the acts of a third party. In the restatement of torts, it set forth the applicable rule. A possessor of land who holds it open to the public for entry for his business purposes is subject to liability to members of the public while they are on the land for such purpose, for physical harm caused by the accidental, negligent, or intentionally harmful acts of third persons or animals, and by the failure of the possessor to exercise reasonable care to A, discover that such acts are being done or are likely to be done, or B, give a warning adequate to enable the visitors to avoid the harm or otherwise protect them against it. Comment F of this section is particularly pertinent to this case. The duty to police premises. Since the possessor is not an insurer of the visitor's safety, he is ordinarily under no duty to exercise any care until they know or have a reason to know that the acts of a third person are occurring or are about to occur. He may, however, know or have reason to know from past experience that there is a likelihood of conduct on the part of third persons in general, which is likely to endanger the safety of the visitor, even though they have no reason to expect it on the part of any individual. If the place or character of their business or their past experience are such that they should reasonably anticipate careless or criminal conduct on the part of third persons, either generally or at some particular time, they may be under a duty to take precautions against it and to provide a reasonably sufficient number of servants to afford a reasonable protection. The appellate court findings, they found that the University of Notre Dame was aware that alcoholic beverages are consumed on the premises before and during football games. The university was also aware of the tailgate parties held in parking areas around the stadium. And even though the university had no reason to know of a particular danger posed by the drunk who injured Mrs. Behrman, they had reason to know that some people would become intoxicated and pose a general threat to the safety of other patrons. In this case, Notre Dame had a duty to take responsible precautions to protect the people who attend their football games from injuries caused by the acts of third persons. The questions whether the protective measures employed by Notre Dame were inadequate, and if so, whether such inadequacy contributed to Mrs. Bierman's injury, are questions for the jury. The Court of Appeals reversed their judgment of the trial court and remanded the case for proceedings consistent with this opinion. Implications for the athletic administrator. The athletic administrator has a duty to plan, a duty to supervise, and a duty to warn. The duty to plan, this duty transcends all the other duties. They can analyze potential hazards such as tailgating areas and intoxication of spectators, and develop strategies that prevent or reduce potential for injury or loss. Facilitating facility evaluation, possible to utilize a separate parking area for invited guests, having emergency response units available, such as police, paramedics, and security personnel. These units should be present before, during, and after the event. Revisit these plans regularly and update accordingly. The duty to supervise, have security, police, and emergency personnel present and visible to control impulsive behavior, prevent foreseeable injuries, and to respond in an appropriate manner and time frame. Have supervisors on site to coordinate security and emergency personnel. Have security personnel moving throughout the crowd to spot potential dangerous situations. Have them remove unruly spectators to keep the area safe for everyone attending the event. The duty to warn. They can place warning signs in areas where alcohol is prevalent, so other spectators can steer clear of those areas. And they can make announcements reminding spectators to be responsible and considerate of all spectators in attendance. This concludes the presentation.